Dear ladies and gentlemen, thank you for the chance that given to us to present our paper. Before I start our presentation, let me introduce myself. My name is Girvan as the author and presenter, and with my partner, Mr. Muhammad Reza Syariffudin Zaki as author. As a representative, I would like to present our research and thoughts to the legal protection of consumers that obtain money from illegal online loans. Introduction. The development of information technology today has had a huge impact on human life. One of the concerns is in financial sector through online loans. Online loans offer loans with a easier and flexible terms and conditions compared to the conventional financial institutions such as banks. This can be seen in Hootsuite data, which showed that the number of internet users in Indonesia in January 2018 reached 132.7 million users. In addition, the population of mobile device users has an even higher number, 170.9 million users. Based on this data, it's not surprising that the role of online loans in Indonesia is increasing rapidly. Based on the Financial Services Authority or OJK, as August 2020, there was 158 company that works on online loans. According to the Finance report, it was stated from the January 2020 to March 2020, 508 illegal fintech lending entities were found. So this is the problem that cause of the three main points in the last slide. Above all the benefits, of course, there is a problem in the development of technology. This illegal status raises the question of whether consumers who have borrowed money from illegal lenders need to pay their loans. Considering that the status of business entities from illegal lenders is not valid. Method. This study used a normative juridical method where the author looked through library materials or secondary data, which may include primary and secondary legal materials. More specifically, this research used juridical norms. Result and discussion. In result and discussion, authors divide into two perspectives, civil law perspective and criminal law perspective. In civil law, there are 2 points, Article 1320 of the Civil Code and illegal status from OJK. In criminal law perspective, there are 3 main points, Article 368, Article 335, Paragraph 1, and Article 29 IPI law, into Article 45B. Article 1320 of the Civil Code. So based on this article, an agreement can be said to be valid if it fulfills 4 conditions, subjective and objective. In subjective, there must be a capacity to conclude an agreement, and there must be consent of the individual who are bound thereby. And in objective, there must be a specific subject and there must be an admissible cause. So if an agreement didn't fulfilling the subjective, it's called voidable. But if it's not fulfilling the objective, it's null and void. Null and void from the author of an agreement has been void or is considered non-existent. If the objective conditions are not met, the agreement is null and void. From the beginning, there has never been an agreement, and there has never been an engagement. And the second one is voidable. If one of the subjective conditions is not fulfilled, the agreement is not null and void, but one of the parties can request the cancellation. So based on the explanation above, because illegal online loans are not legal business entities according to Indonesian law, it is considered that there has never been an agreement and is null and void, or we can say voidable the objective terms and conditions. Therefore, consumers do not need to pay loans to illegal online loans. In addition to the basic civil law, which can be used as a reason why illegal online loans do not need to be paid, this is reinforced by the basis of criminal law. The criminal law that forms the basis for this are, so for the criminal law, we have Article 368 of the Penal Code that says any person who, with the intention of unlawfully benefiting himself or another person, forces a person by force or threat of violence to give something which wholly or partly belongs to that person or another person, or to make a debt or write-off of debt, is threatened with extortion. So in this article, the main point is violence. So what is violence? There is a four definition of violence. The first one, forcing others, and the second one, to provide goods which are wholly or partly belonging to the person himself or belonging to another person, or to make debts or write-off receivable. The third one, with the intention of benefiting oneself or others by violating rights, and the fourth, forcing it by using violence or threats of violence. So the key point in this article is violence. The second one, in criminal law perspective, we have Article 335, paragraph 1 of the Criminal Code. This article regulates the act of forcing a person to do or not to do something with the threat of violence or violence. Regarding violence and threat of violence, from the formulation of Article 335, paragraph 1 of the Criminal Code, must be met for proof, which must be proven in this article are, the first one, that there are people who are against the right to be forced to do something, not to do something or to allow something. And the second one, the coercion is carried out by using violence, not the act or an unpleasant act or threat of violence. The threat of another act or the threat of an unpleasant act either to the person or to another person. So based on this article, it's sufficient to prove this offense by fulfilling one of or the two elements, threat of violence or violence. The definition of violence in this article of the Criminal Code refers to the Article 89 of the definition of the violence. I'm sorry. Where the definition of committing violence is to use force or physical strength that is not small and illegal. But in the practice of the illegal online loans, it's not uncommon to find that threats occur through electronic media. Therefore, the IPI law plays a role in this criminal perspective. We have Article 29, IPI law, junto Article 45B. In the explanation of the Article 45B, it is explained that the provision in this article also includes cyberbullying, which contains element of threat of violence or intimidation and result in physical. psychological and or material harm. For the perpetrators, of course, they can be criminally processed because it's not stated in the action is complaint offense. So it can be understood that from the provision in this article 45B are ordinary offense so that anyone can submit a report to the Indonesian National Police investigator or employee investigator. So this is the result and discussion. And then we go to the last part of the presentation, that is conclusion. So based on the author's analysis, consumers who have borrowed money from illegal online loans do not need to pay for the loan. This is based on the article 1320 of the Civil Code, where the illegal status of illegal online loans make an agreement between illegal online loans and consumers null and void, or we call Indonesia batal demi hukum, for violating objective conditions. So that is considered that there was never been an agreement. In addition, if in practice there is a threat of violence either directly or through electronic media, consumers are protected by Article 368 and Article 339, Paragraph 1 of the Criminal Code and Article 29 of the IPI Law, Junto Article 45B. That is all from me. Thank you for your attention. I hope this presentation and study has given us new insight about illegal online loans in Indonesia. Thank you.